Well, kia ora koutou. It's a real pleasure to be here and talking about such an important topic. So my name is Jessica and I'm Executive Director at Lawyers for Climate Action. So we're a group of lawyers from across the country committed to using the power of the law to make meaningful action on climate change. And I've been asked to speak today specifically about the consequences of this judgment for domestic law and policy. And this is really important. As Vernon said, almost read the same as the first few sentences of my speech, the ICJ advisory opinion, when it came out, was celebrated in climate circles as a landmark judgment, as a cause for celebration. It's one of the most positive, exciting things that's happened in what can otherwise be a pretty bleak area to work in. But then that does lead to the obvious question, which I'm asked quite a bit, which is, well, what next? What does it matter? What does it mean? What does it mean for New Zealand in practice? And of course, we've got a dualist system of law. International law doesn't automatically become binding on New Zealand, but we have signed the Paris Agreement. We are bound by customary international law, and there's a presumption of consistency so that decisions made by domestic decision makers ought to be consistent with international law. So I'm going to make 3 points in the next 10 or so minutes. One, that New Zealand has obligations under international law to have a strong climate law and policy response, irrespective of whether we are a member of the Paris Agreement. Two, our climate targets need to be more ambitious. They currently don't pass muster, and the ICJ advisory opinion ought to be giving the New Zealand Cabinet an awful lot to think about. And three, it's actually not enough just to have climate targets in place. We need to be meaningfully implementing them as well. And in fact, we've got stringent due diligence obligations to do just that. And again, New Zealand isn't really passing muster, in my view, in terms of whether or not we're doing that. And I think it calls on New Zealand to strengthen its climate law and policy response. So let's talk about the first point. So the ICJ found that states unequivocally have obligations to reduce the harm to the climate system and to reduce their emissions. And importantly, this arises under a number of different aspects of international law, as Caroline set out. It applies whether or not New Zealand is a member of the Paris Agreement. And I make this point in a political context where there are calls for New Zealand to pull out of Paris. Also, there's suggestions that New Zealand really ought not try too hard. If we're a member of Paris, we can just get away with doing as little as we possibly can get away with and shouldn't put our head far up above the parapet. But this judgment makes clear that's really not okay or an answer that flies under international law. New Zealand has legal obligations to reduce emissions. The fact that we're small doesn't actually matter. We're a developed state with the capacity to do more. Pulling back from pursuing meaningful emissions reductions and not doing our fair share is a breach of international law. And not only does this raise reputational risks for us as a country, it raises trade risks, but also critically legal risks, which I'm sure we will come to later. So that's the first point. We as a country, party to the Paris Agreement, member of the international community, have obligations to pursue emissions reductions. So then the question is, well, how are we doing that? And I'll start by talking about our targets. In particular, I'm going to talk about our NDCs set under Paris. So what did the ICJ say about these NDCs? So as Caroline said, they're the primary targets that states have to come up with under the Paris Agreement. And in the arguments before the ICJ, a number of countries, New Zealand to be fair, argued that states have full discretion to pick NDCs at whatever level they really want. They're nationally determined, and that provides a really wide range of discretion. But the ICJ said that states' discretion is limited, and it said that in two particular ways. One, it said that the content of NDCs is equally relevant to determining compliance. And two, that states have stringent due diligence obligations to ensure that their NDCs fulfill the requirements of Paris, to ensure that they're progressive, ensure that they're highest possible ambition, ensure that they align with the 1.5 primary temperature goal that the ICJ set out. So in other words, what this means in kind of normal people speak is that states have to do, and I quote, the utmost when setting their targets to make sure that they represent highest possible ambition and realising the objectives of the agreement. Okay, so that's what the law is. How does our NDC map onto that? Well, New Zealand, to its credit, was one of the first countries in the world to actually put forward their NDC. We did that back in February. But merely setting and communicating an NDC isn't actually enough. That's one of the points that the ICJ made. We actually have to look under the hood. And several experts, and also arguably officials, have raised some real questions about whether our 2035 NDC passes muster. So our 2035 NDC, as Caroline said, is for 51 to 55% reductions by 2035. That is a very, very small increase on our previous NDC, our 2030 target, which was for 50% reductions by 2030. So 51 is a slightly bigger number than 50, but is it really within the spirit of the Paris Agreement? Does it reflect our fair share of emissions reductions? Bearing in mind we're a developed country, we've got the highest methane emissions per capita of any country in the OECD. Is this really us doing our fair share? Does it reflect our highest possible ambition? Well, the Climate Change Commission thought that New Zealand could achieve 69% of emissions, 69% reductions by 2035 domestically alone. When officials were advising the Minister of the NDC, they called this the minimum viable option. So it feels a bit like a tautology to me. The standard is highest possible ambition, and officials see this as the minimum viable option of highest possible ambition, which again, I just don't think is within the spirit of Paris. And here's some other relevant information for you, which is that today, Australia, our coal mining neighbour, announced its second NDC of 62 to 70% reductions by 2035. And if I'm not mistaken, their previous NDC was for 47% reductions by 2030. So we are now being significantly outpaced by Australia in terms of our climate ambition. So not only is that embarrassing, and I think bad for our international reputation, the impact of this judgment is it clarifies to me that it's probably inconsistent with our international obligations as well. Okay, so how's that for a rosy picture in terms of the first way in which we might not be complying with international law as expressed by the ICJ? But having your targets in place actually isn't enough. The ICJ made clear that we also have to pursue domestic mitigation measures with the aim of achieving the objectives of our contributions. And this means that states have to exercise best efforts, be proactive to pursue measures that are reasonably capable of achieving their NDCs. And those aren't my words, they're all words in the ICJ judgment itself. So how are we doing in that regard? And I'll focus here on our 2030 NDC. So in terms of form, New Zealand doesn't look too bad. So we have an overarching climate framework law, the Climate Change Response Act. It's robust. It sets out systems of emissions, budgets, and a net zero target. It's set up an independent climate change commission who advises the government on our targets, on emissions reduction policies, and monitors how we're going in terms of actually implementing them. We also do have rules that regulate the conduct of private actors within the government's control, something else the ICJ said falls within states' obligations. However, form isn't enough. That's what the ICJ made clear. Substance matters too. So here's 5 areas where I think we're substantively not quite meeting the mark. I promise they're short. 1, we're currently 84 million tonnes short of meeting our 2030 NDC, and the government doesn't have a plan for how we're going to meet it. I think that's a really big issue. 2, the Climate Change Commission said that there are serious risks of us meeting our 2050 target. That means there's serious risks of whether New Zealand is actually meaningfully contributing to the 1.5 temperature goal. 3, our climate response is contingent on planting literally hundreds of thousands of hectares of pine trees. Not only is this damaging the social license required to maintain political consensus for climate action, is it sparking huge backlash in our farming and rural communities. It also, in our view, doesn't align with best available science. If we don't reduce emissions at source, we're going to continually have to plant trees for decades to come in order to offset our emissions. And the United Nations Environmental Programme has put out a report that says there's literally not enough land on the planet to plant all the trees that companies and governments around the world have committed to buying. 4, the ICJ said that the granting of fossil fuel exploration licenses or the provision of fossil fuel subsidies could be an internationally wrongful act. So, within days of the International Court of Justice releasing this advisory opinion, the New Zealand government repealed the ban on offshore oil and gas exploration introduced by the Minister for Climate Change in the House. We've also introduced a subsidy for fossil fuels, $200 million to subsidise fossil fuel exploration. Doesn't seem particularly consistent with the ICJ. 5, how are we going in terms of regulating private actors? Well, probably the main thing that we do there is the emissions trading scheme, which is pretty well established. It's not fit for purpose. It doesn't cover all of our emissions. In fact, it continues to exempt agriculture. Auctions don't pass month after month. And there's a huge stockpile of credits that mean it's not actually putting a real price on carbon. So the release of the advisory opinion was such an exciting moment for international climate law and climate action. It makes clear that states, including New Zealand, have obligations to reduce emissions, to protect people and the planet. But in my view, New Zealand has a bit of work to do. Our targets don't pass muster. Instead of pursuing emissions policies that are really going, things like electrification, pursuing that kind of policy platform with gusto, we're introducing new fossil fuel subsidies and continuing to refuse to fix a broken ETS. In my view, the ICJ advisory opinion should be a catalyst. It could be a moment for reflection for New Zealand to change course, and I hope that around the cabinet table, there's discussions about whether or not New Zealand should change course and start making decisions that are more consistent with our international law obligations. And I think that requires a step change in